Okay, it's Friday the 5th of June and I'm just taking a look at my Twitter feed. I see one of the first things that comes through there on it is a case that's referred to by Barry Crushall, solicitor, who's retweeting Wendy Doyle, solicitor's tweet, but it's about dismissal, disability and reasonable accommodation, award of 2 years' salary. This actually is my case. It's a case that I brought on behalf of the employee and have written about it on my website employmentrightsireland.com, and I've made a video about it as well if you want to have a look. But the commentary here is that the case involving a shop assistant and a hardware and tool hire centre is very useful for summarising the law, where an employee is absent on sick leave and the obligation on the employer to make reasonable accommodation for the employee and so on. That claim was brought under the Employment Equality Act, and the question arose, or the decision had to be made, as to whether to bring it under the Employment Equality Act or the Unfair Dismissals Act, and we brought it under the Employment Equality Act, thankfully. The next tweet I see there that might be of some interest to somebody, or to people generally interested in the law and indeed interested in a quiet night's sleep and so on, is to do with the tort of nuisance. Emergency legislation is being urgently demanded to help Gardaí tackle lockdown house parties, and that's to do with the whole COVID-19 situation and the development of house parties apparently becoming a thing, which obviously is incredibly irresponsible and selfish. But you can make an application through the District Court under the Environmental Protection Agency Act 1992, which involves the tort of nuisance. A tort is a civil wrong. Any significant interference with the peaceful enjoyment of your home is a serious matter, and you can seek a restraining order through the District Court. So that's something that you might consider if your neighbours are carrying on and making life difficult for you, and obviously there is a serious amount of dismay as well on behalf of many people who would be absolutely frustrated at neighbours and having parties in the current COVID-19 circumstances, especially when you have small business owners facing ruin, quite frankly, who are unable to trade. And I've had many small business owners contact me with various issues over the last few weeks and indeed months, to do with employment law, to do with being allowed to open up again, to do with competitors perhaps trading on the sly, and so on. And it really depends on your business and the nature of your business as to where you fit into this roadmap for returning to work or returning to some degree of normality. I see Claire Bruton, who is a barrister, a very well regarded barrister in employment law. She has written an article there apparently in the current edition of I think it's the Law Library or the Bar Council's magazine, and it's to do with employment law and the whole question of working from home and what employees and indeed employers should learn about working from home. Just having a look at the tweet here now. Yeah, it's in the Law Library, and it's to do with that article. It's in the Bar Review, the Bar of Ireland article. Actually, I must have a look at that myself, because I see I have access to it. I wasn't aware of that, so I will have access to it, and I'm going to have a look at that to see what it says, because Claire Bruton knows her stuff when it comes to employment law. There's plenty of tweets there now as well about the return to business, to what approaches or might approach normal business. And I see there, as businesses continue to reopen over the coming weeks, it's important to have an up-to-date employee handbook. Okay, as I was saying there's quite a bit of tweeting about, and obviously concern about businesses going to reopen, and the requirement or the good sense in the businesses having an up-to-date employee handbook covering any new changes in the workplace. So obviously the whole return to work situation would have brought about this return to work safely protocol for employers, and obviously that may have brought about some changes in the workplace and may have brought about some requirement to change the employee handbook. I'm not sure, to be honest with you, the extent to which the employee handbook would need to be changed to reflect the changes in the workplace with a view to making things safer for employees and so forth. But that's something that you perhaps should consider, depending on, I suppose, your particular circumstances, what type of business you have and so on. I see there a tweet that large stores and playgrounds are to reopen on Monday ahead of the schedule, according to the Irish Times. So that's good news. Anything that gets us back to some degree of normality has to be welcomed. I see Orla O'Donnell there tweeting. Orla O'Donnell is the RTE, I think she's the legal affairs correspondent, but she's referring there and tweeting about the O'Doherty and Waters case, where they brought the High Court proceedings, judicial review about the COVID-19 lockdown and so on and so forth, but the High Court issued its ruling yesterday in relation to costs. And amongst other things, Mr. Justice Meenan said the manner in which they conducted their proceedings, their failure to consider or answer the case being made against them, and to only have regard to their own opinions, meant these proceedings were very far from being in the public interest. And the cost of the 2 days High Court hearing was awarded against Waters and O'Doherty. And anybody who has ever had any concern about going to court, or who has ever turned their mind to worrying about the cost of going to court, will obviously not disagree with this ruling, because if you go to the High Court, or indeed any court, and you lose, then there is consequences that must be visited upon you, unless there are public interest issues and reasons for doing so. And clearly in this case, O'Doherty and Waters' case was not held to be in the public interest, or at least the way that they conducted the proceedings were far from being in the public interest, to quote Mr. Justice Meenan. I do understand that they're going to appeal this, and again, that's a matter for themselves, but at the moment the High Court's costs, or the cost of being in the High Court for the 2 days, has been awarded against Gemma O'Doherty and John Waters. There's a good few tweets there now as well about redundancy and the entitlement, if any, to enhanced redundancy payments, wage cuts, layoffs and so forth. In my own practice here, I am seeing a lot of redundancies. I'm seeing a lot of queries from employees about layoffs, about short time, about redundancy, about what the difference is and so on. You would need legal advice, but from an employer's perspective, you need legal advice as well, just to steer yourself through safely the rocks that is employment law in Ireland. But redundancies and claims for redundancies and claims for unfair dismissal arising from purported redundancies are claims that probably are going to spring up in great quantities, in prodigious quantities in fact, in the WRC over the next period of time. And I see Richard Grogan soliciting there that the UK is bracing for a redundancy surge, and the WRC can expect a similar surge here. So I certainly wouldn't be surprised to see that. And finally, in this video, I'm looking at Barry Crushel's video, or not video, tweet about Sweden. Sweden has had 4,468 COVID-19 deaths, whereas Denmark and Norway, each with about half their neighbours' population, have had 580 and 237 respectively. I'll just give you those figures again, because at the outset of this COVID-19 storm, people were looking at Sweden and saying, why can't we be like Sweden? Why can't we do what they do? We could have done that all right, and we could have suffered the catastrophic number of deaths that they have suffered. And the Swedish expert now admits country should have had tighter coronavirus recommendations and procedures in place. But to give you the figures again, Sweden has twice the number of population of Denmark and Norway, and yet Sweden has had 4,468 COVID-19 deaths, whereas Denmark and Norway have had 580 and 237. Now, if you were a public health official And if you were the public health official who steered or encouraged or aided and abetted this particular policy, I'd feel pretty bad. It's like a fella going to the casino and putting everything on red, and black comes in, the ball lands on black, and you walk away. There's going to be a commission to investigate in Sweden, in Stockholm, their approach to the pandemic. But it's interesting, as I say, to see what has happened over the effluxion of time, as it were, and to see exactly how enlightened the Swedish approach was, or how enlightened the Irish approach was, for example, versus even the UK. If you watch Channel 4 News any night, you'll see that the death figures, the mortality rate from COVID-19 in the UK is absolutely appalling. So I think, in fairness, we have done a pretty good job so far, and hopefully it will continue to dampen down and we'll get over this. Hope you find this video useful.